When is a blood test preferred as opposed to a breath test in a DUI case? Attorney Michael Sahn explains. In a misdemeanor DUI case, a blood test will only be offered if the person is physically incapable of providing a breath test. Generally, this would occur after a car accident where the defendant is taken to a hospital and is either unconscious or otherwise unable to provide a breath test. Under these circumstances, an officer can request a blood test, but it must be ordered by a trained healthcare worker who agrees that it is the only way to obtain a blood alcohol concentration from the person. For both chemical breath tests and blood tests, there are time limits for securing those samples. If they are not secured within the required time period, they cannot be used against the defendant. There are a number of reasons that a police officer may not show up for trial. For example, an officer could have retired, transferred locations, or sustained an injury. If a police officer fails to show up for a DUI trial, the charge could be dismissed. DUI cases are taken very seriously, and police officers are often subpoenaed by the prosecution. Another reason that an officer may not show up for a trial is if they were not subpoenaed properly by the prosecution. Contact Attorney Michael Sahn in Charleston, South Carolina today. He provides clients with aggressive and skilled representation in some of the most difficult legal situations.